Okay, so that's, I guess, my conclusion after some years of watching law reforms take place, of watching the process of law reform, being involved in the debate about law reform, watching it being implemented, and then looking at the monitoring and the evaluation after that. And I'd be arguing that, surprise, surprise, this situation should not be allowed to continue, that all victims are entitled to respectful treatment, victims are entitled to equal access to justice, and victims of sexual assault are not being accorded those rights. They're not getting the same access as victims of other crimes, and they're not having a range of their needs and interests addressed in the criminal justice system at the moment. So when victims talk about what they're looking for in a legal process, they're saying, well, this has happened to me, what are my range of options? So I want to go through a legal process, what am I looking for? And victims have highlighted, for example, that they are looking for retribution, that they do want punishment, but also, again, with various levels of sort of expectation, I guess, that they want a voice in the process, that they want to have some say in how it works, that they want acknowledgement by the offender. So a not guilty plea, even if it results in a conviction, is dubious in terms of its actual acknowledgement by the offender. Yes, this is what happened. I accept this is what happened. Wanting acknowledgement also from the wider community of the nature of the harm that they've experienced. And many want a mechanism that stops that violence from continuing. The violence by that offender against, for example, members of a family, continued members of a family, other women, and so on. And some victims also want an apology, they want compensation. So I'm just wanting to highlight that when people come to the criminal justice system, they may well come with a lot of different expectations, and different victims will have different needs and expectations. Hence the argument in this paper then, this presentation, for the development of an alternative pathway for appropriate cases, drawing on the concept of restorative justice. So restorative justice is about the acknowledgement by offenders to victims of their responsibility for the harm that's been suffered, in a setting which allows the victim to tell her or his story in their own terms. And I'm arguing that there is the need for an alternative pathway as another option, an alternative pathway that still works within the criminal justice system under the auspices of the state, but that better addresses the needs of victims whilst also protecting the rights of accused persons. Okay, so it's quite a challenge. So I'm proposing that there should be a formalised referral process, so that when the matter first comes into the auspices of the prosecution, that there are decisions that are made with the victim about the best approach. Procedures for referral would be statute-based. There should be some clear provisions for the criteria for referral, considering the public interest, victims' interests, the likelihood of a successful outcome, and so on. And I guess one's envisaging a sort of multi-agency process, and I haven't tried to formalise or formulate at this point the details of what that process would look like. What I'm wanting to really do is make the argument and then look at what are some of the reasons for having this argument. So I guess under that heading options, you'd see the first consideration would usually be prosecution. Is that going to be an option? But also one might look at alternatives where prosecution doesn't look like an option for a range of reasons, which I'll come on to, where one might simply look the most straightforward, simple option which requires no engagement with an offender, and which currently many victims do already access, is a compensation pathway, where they can apply for crimes compensation as a victim. They can get some funds for perhaps replacing the bed that they don't want to sleep in again, getting fresh clothes, getting new locks on the door, having a break for a while, having a holiday, etc. So there are already processes in place for relatively small amounts of compensation. That would be the simplest option, and that's already in place. However, it might be possible then to add on to that process access to what's referred to as a restorative justice conference, a meeting, which might, in appropriate cases, provide some of the outcomes that the victim's looking for beyond the compensation one. So I'd recognise, first up, at least two key limitations: a limitation of principle and limitations in practice. In principle, there might be very few cases which the community would accept as being appropriate to be dealt with using this sort of model. We may feel that there are not that many cases that we'd want to have dealt with in a non-adversarial way, but it's simply not the right thing to do. We should be sticking to a prosecution model. But I just note there that in discussions with victims and victim advocates, there is some value in thinking about different categories of case. So we might want to differentiate young offenders and adult offenders. We might be slightly more willing to think about this as a pathway with some intra-familial sexual abuse, abuse within families, perhaps sibling abuse, abuse between juveniles, child victims of abuse, adult survivors of child abuse in relation to their family. There are perhaps some ways of thinking about different types of victims and relationships which might be more thinkable, I guess. We might want to categorise some victims or indeed some offenders as more vulnerable and therefore more appropriately offered an alternative pathway. For example, victims where there are issues around the age of the victim, either being elderly or being young, around disability, around cognitive impairment. There could be a whole range of factors of the way in which a victim will experience the system that might make this an option that we do have to think about. But those are the in-principle concerns. And clearly the most in-principle concern is this even thinkable? Is this too soft an option for such a serious offence? And I recognise that as well. And it's taken me, as I say, a long time as a feminist critic of law to even be able to consider this. And it's been the failures of law reforms throughout the last decades that have driven me to say we've actually got to find something else because there are so many victims who are not getting anywhere with the criminal justice system. Okay. In principle, in practice, there may be not that many cases where an offender is actually willing to acknowledge responsibility, because this sort of restorative or counselling or conferencing pathway has as its prerequisite the recognition of responsibility by the offender. It's not a fact-finding process. Fact-finding processes are done in courts with all the full protections. These sorts of pathways must begin with an acceptance of guilt or responsibility by the offender. So in practice, how many cases will there be? I recognise those. So what might an alternative pathway offer? In broad terms, we're talking about a conference model where victim and offender would meet potentially around a table. Doesn't have to be around a table, but that's the way it is done where it's done, with their family members if they want them, with community members, with friends for support, and with a facilitator in a private environment. It wouldn't be in a courtroom. Centrally, the central, attraction of a conference model, what's referred to as a conference or restorative justice model, is that it is discursive. It's actually about talking, and it's non-adversarial. So it gives a voice to the victim. It makes him or her central to the process. They are the centre of the process, which is not the case, of course, in a trial. The steps would tend to be, commonly, the victim would say what happened. They would tell their story. This is what happened to me. And the offender would then be given the opportunity to acknowledge that, to respond to that, to perhaps deal with how that occurred. So the process emphasises the accountability of the offender, both to the specific victim and also to the broader community. And the victim can ask the questions that they often say they want to ask, not just victims of sexual assault, but victims of other assaults and other, for example, house burglaries. Why me? How did it happen to me? What is it about me that made this happen? And generally speaking, they find immense reassurance from the notion that it may well have been completely random, for instance, that it wasn't your fault that it happened. So those sorts of questions can be asked in that context, which never arise in the context of a trial. Defendant does have a chance to actually take responsibility, to offer some form of reparation, to apologise, to provide financial compensation, whatever seems to be appropriate. I haven't forgotten about the problem of punishment, and I'll come back to that depending on my time. There are claims made that the conference model does reduce reoffending. Others would argue that the conference model, which is used in many sort of fields of minor criminal offending now, right? But it's not used in this particular field very much, as I'll mention. But there are certainly claims that it leads to much higher victim satisfaction with the process and with the outcome. Victim satisfaction can be fairly high in some of the programs that have been run. Offender satisfaction reasonably high. Reduced stress on victims clearly significant. And in some cases, there does seem to be evidence that it reduces reoffending as well, which is what you'd be really hoping for, where an offender genuinely takes responsibility for their actions. Conferencing outcomes can be linked into treatment as well, so that they can be part of the deal, can be that the person goes and has treatment for whatever sort of condition or problem they had that might be amenable to treatment. Conferencing is intended to provide a clear statement of the wrongfulness of the behaviour, and it does that both by the discourse between the victim and the offender, but also by the existence of community in the room. So whether it's family members, whether it's neighbours, whether it's community, for example, elders in an Indigenous community, it's seen as very important that that process be very affirming of the victim's complaint, the victim sort of saying this is what happened, and very clear as to the wrongfulness of the offender's behaviour. And that, I think, is probably the closest parallel you get with the criminal justice system, with that notion of denunciation and retribution. It can have a real process of shaming involved in that, and there's a lot of literature about whether shaming is a useful or not useful mechanism in these areas, but the conference is seen as being a very clear model for shaming, which doesn't happen normally or readily in the court's process, I don't think. Victims who are, for example, adult survivors of intrafamilial abuse, so whether the adult was abused as a child, often raise the concerns when they go to see, for example, sexual assault centres or clinics or counsellors, about wanting to maintain the broader family unit, that if they complain to the police, report to the police, go through a trial and so on, that they see the implications, ramifications for their family and their broader family as so damaging and so harmful that they don't know that it would be worth it to go through the trial process. And for victims who are adults in this case, some even still want to maintain a relationship with the original perpetrator as father and so on, brother and sister and so on. So the conferencing process does offer that less adversarial model, whilst at the same time requiring the very clear acknowledgement of the harm. And for victims in this situation, they can say, and it has been said when they go to some of the cases, that that's really what they want. They just want them all to acknowledge this is what happened and it was wrong, because it's usually hidden and denied and so on in the sort of development of the family intergenerationally. Procedures can be flexible. As I mentioned, it can take account of age, they can take account of needs of disability, they can take account of language difficulties, cultural needs. They can be very flexible in the way they're structured to take account of what the victim, what the parties need in those processes. And finally, I would emphasise that the reason we're talking about this, well, I'm talking about it, you're listening to me, hopefully you're thinking about it, is because conferencing might in fact offer some remedy for people who will not otherwise have a remedy. I'm not thinking about getting rid of the existing system. We're saying let's add in some of the victims who currently have no remedy. Is there another way of providing some sort of an avenue for them as well? And that's, I guess, the importance of it. Okay. Benefits for the offender. It's not the main focus of my presentation today, so I just note there, the highest ideal of conferencing would say that the best restorative justice conferencing is actually transformational for the offender, that they finally realise the harm of what they're doing or have done and change. They actually become a different person. I just note that there. Conferencing, therefore, can possibly address offending behaviour. In some cases, it is shown to reduce reoffending. It's usually connected to a decision by the court process that the person will not then receive a conviction. So there are quite a lot of practical and procedural benefits for offenders as well as for victims. And that's going to be relevant when we think about that earlier question that I raised, which offenders are going to actually put their hand up and admit and go into this process. And that is I guess, the sort of the nub of it, because this issue about the high level of not guilty pleas, if we go back a few of my slides, is in a sense the nub of the problems with the criminal justice system for victims as it is. So the whole question of how we can facilitate and encourage greater rates of acknowledgement by offenders is, I guess, central to the discussion as well.